You're under arrest for armed robbery.
You have the right to remain silent. If you give up this right to remain silent, anything you say can and will be used against you in a court of law. You have the right to an attorney. If you desire an attorney and cannot afford one, an attorney will be obtained for you before police questioning.
Prove it. I ain't seen anything until I see my lawyer. I want to see my lawyer.
What's your full name?
Ronald Charles Manning.
What is your address?
I ain't going.
Okay. Where's the knife that you had along with this when you ripped off the Max Milk at Wilson Avenue?
You're lying. I only had the gun. The knife was in the toolbox in the car, man.
Whatever, punk. You better get your head together for the bail hearing. It's within the next 24 hours. For now, you'll be held in custody.
Okay.
What the judge was saying, man, but I want to give him my freedom.
Well, in order to be granted freedom, for bail before a preliminary hearing, you have to have an address, which you don't have, a place of employment, which you don't have, and you need surety.
What's a surety?
Basically, you need supervision when you're let out on bail. Anyway, the preliminary hearing will be soon enough. We'll prepare for that.
We're back here again?
Yeah, both bail and preliminary hearings take place here. Anyway, we're here for what's called a prima facie case.
What case?
Well, they want to make sure that there's enough evidence before they try the Crown trial. So, yeah.
Alright, sorry. No cameras or reporters in the courthouse.
Well, I'm sorry there was enough evidence, but we'll prepare well for our trial in the Ontario Superior Court of Justice. Don't worry about it. Don't worry, we'll take this to the Ontario Court of Appeal.
Do you really think we'll win?
Well, considering that the basis of your conviction was what you said to the police officer when you were under pressure, after you asked them to have a lawyer, I mean, that violates Section 10D of the Charter, so I think we do have a pretty good case.
At issue here is whether the accused's statement should have been excluded from evidence on the grounds that his rights under Section 10B of the Charter, the right to counsel, had been violated. In the case R v. Manningham, the police should not have questioned the accused after he expressed a desire to speak to his lawyer and the intent to say nothing until he did so. While the first two questions were innocuous, the third was in a completely different category. More importantly, the question was asked as if the appellant had expressed no desire to remain silent and to see his lawyer. This conduct by the police brought the administration of justice into disrepute within the meaning of Section 24(2) of the Charter, and the evidence obtained thereby should be excluded. The conduct of the police was willful and deliberate, and more than a blunder or mere technical transgression. The police's conduct went beyond what was unfortunate, distasteful, or inappropriate. Appeal allowed and the conviction quashed.
Yay, I'm free, I'm free!